So this is case number 2401653 GC Calvary SPV1 LLC versus Tarina, Tarena Ingram.
Good afternoon, Your Honor. Jeff Warber, P67124 on behalf of.
All right, Mr. Warber, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarena Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
No problem. We have to do that. All right. And so today, from my understanding, I don't have a separate, submission with respect to this matter. It's my understanding that this is a Judge Arvant case and that there was a ruling on a motion to disqualify the judge, and she denied it for some reasons that she stated on the record. So I don't have a transcript of that. But you've asked me as Chief Judge to review the whole situation, pretty much de novo, as to whether or not Judge Arvant should be, in fact, recused from the case. So what is your basis that you're claiming that she should be recused from the case?
My basis is I compelled the motion, the date of the deposition, to compel to arbitration per the credit card agreement. I stated that I could compel arbitration at any time as long as there wasn't a default judgment or a trial started.
Okay.
So I did.
So this was a credit card debt.
Yes.
With the plaintiff, Calvary SPV now. And you're
Okay.
saying that whatever the agreement was on the underlying debt involved an arbitration agreement.
Yes.
And you're saying that that agreement specifically said that you could request it at any point in time.
Yes.
Okay. So what is the basis for the recusal of the judge?
She denied the motion
Okay.
and to a default judgment.
Welcome back to Courtroom, folks. And buckle up, because today's case is one of the most spectacular displays of courtroom delusion you're likely to see. We're dealing with a textbook Karen meltdown, but not the ordinary complain to the manager type. No, this one marched herself into court and attempted the ultimate tantrum move, asking a chief judge to remove the original judge simply because she didn't like the ruling. This case is a front row seat into the world of misunderstood legal procedures, mistaken self-confidence, and emotional spiraling, all wrapped into one dramatic.
Yes. And this
Lawyer?
attorney violated a lot of my rights. The debt was only $1,877. I never denied the debt, but this attorney never served me the original summons. Never served me.
Okay, but I can't, no, let me tell you what I can't do.
Okay.
What I can't do, because Judge Arvant is in charge of her rulings on
Yes.
her case. So I can't go back and change her ruling on the
Yes.
facts or the law. What I can do is decide if there was anything in the circumstances of what she did that would point to a reason to have her removed from the case.
She showed favoritism to the attorney from the
And how
beginning
was-
of the case.
How was that?
She made biased statements,
Such as?
such as when I told her that I mentioned that I never received the original summons. She said it didn't matter. You were put on notice with the alternative order that I signed.
Was that alternative service?
Yes.
So what we call alternate
A
service?
second summons or alternate summons.
Oh,
Alternative order or
so it sounds like you're saying that she's basically saying if you didn't personally have it, that alternate service would satisfy it. So that's a court ruling. How does that show bias?
it's just statements that she made. She didn't, everything that I said, she didn't hold him accountable for anything. She didn't ask him anything. Well, what steps did you take to serve her? She just showed him favor. He said that, Your Honor, you know me. I've been in your court before. He made oppressive statements, and during the mediation on the Zoom video, the judge is going to enter a default judgment against you. He said it several times, like threatening and abusive and oppressive statements.
Okay, that's what he did though.
Yes.
So here's the thing. The rule really sets out the kinds of things that the judge has to do. this is a pretty high standard to get somebody removed. And I understand you might not like the way she ruled on something. And it could be the case that you don't understand how she applied the law on some things, because I will say this, and I'm not commenting on the validity of her ruling, but I can tell you that alternate service is usually given by court order when someone has had trouble personally serving. And so that is considered good service under the court rules.
Yes.
So I don't know if there was something wrong with her ruling there, but I can just tell you that that pretty much is normal. And if you're following the rules, if the judge is doing that and you don't like it, the real remedy is to appeal it and see, not to me, because I'm not a judge, but appeal it to the next higher court if you think that there's something legally wrong with what she did.
Right.
Because, for this.
Right here at the start, you can already see the foundation of the problem. The defendant believes that judicial disagreement equals judicial misconduct, but a judge denying your motion isn't bias. It's literally the judge doing their job. And when she invokes arbitration, she misunderstands how timing, filings, and court procedures work. The chief judge steps in because she's only allowed to review whether the original judge properly denied the recusal request, not the underlying case, not the debt, not the service issues, nothing else.
The only thing I can do is say whether she should have removed herself or not. That's the only thing I can do, because I'm not sitting as an appellate judge. The appellate judges are at the Oakland County Circuit Court. So you could have done one of two things. Probably you could have asked her to reconsider her ruling. And if there's nothing new you're presenting, then she may not reconsider it. The ruling might be the same. Or you could, within the time frame that's allowed under the court rules, you could file an appeal up to the circuit court. And they would have to look at it and see if she did something wrong I guess, ruling on that
She
motion.
overlooked my complaints of the attorney violating my rights, my civil rights, and as a consumer, she overlooked that. She didn't look into that at all. She just overlooked it and just reprimanded me. She overlooked my rights being violated.
Okay, well, what rights were violated that caused her, that is showing some kind of bias?
Improper service. She didn't look into anything. The documents.
So we just went over the service part.
Well,
alternate service,
and then
might be good.
the oppressing statements that he made during the mediation. To me, that's a violation of the Federal Credit Consumers Act, that a debt collector or whoever's not supposed to make oppressive, abusive statements to collect the debt. He said it several times.
Well, okay, so I don't know what you asked her to do, because I have no transcript. No one has given me a transcript of what actually occurred. And I'm really hearing this de novo, which means from the beginning, as if you never did it over there with Judge Arvin. So I'm trying to understand, what is it? Now, let's just say he did what you said, and he said some oppressive statements to you. What about that causes the judge to have to remove herself from the case because he made these statements to you in a mediation? Which, and let me just say this, normally, whatever's done at mediation, we don't know anyway. We don't really get involved with these.
Okay.
That's called a settlement process.
Okay.
So we usually don't even know what happened at the mediation, and what, if there was an offer or not, and where they were, or how far the parties were apart, what you offered them, what they said they would accept or wouldn't accept. We don't really know that, because that's a settlement negotiation tool.
Okay.
But if you're saying he said something that you thought was offensive, what was it that you asked the judge to do? What was she supposed to do? And how does that show she was biased against you or prejudiced against you? Because it's a very high standard. What you're asking me to do is remove her from that case and have it reassigned to some other judge. Okay. And that's the only thing I can do. I can't look at whether she was correct in her ruling on something, because that's an appellate.
Okay.
That's an appellate issue. But I can say if something she did seem like it was rises to that level of bias or prejudice against you, then I would say that motion, if you're asking for her to recuse herself, then that should be granted. And then I would have it reassigned to someone else. Either myself, it's a blind draw, myself or the other judge could possibly get it. but you would have to meet that standard just on that. So unless she said or did.
And this is where the first major misconception hits like a brick. The defendant claims a judge must be removed because her motion was denied. But if that were a valid reason, every judge in America will be disqualified daily, because every ruling upsets one side. Courts have extremely high standards for recusal. Things like personal relationships, financial conflicts, or clear prejudicial statements. The defendant, however, interprets any unfavorable ruling as proof of bias. This is a classic pro se mistake, confusing procedural outcomes with personal attacks. Instead of appealing to the proper channel, she tries to jump straight to recusal, hoping to undo the.
Well, how's that bias though? That's just a fact that is actually accurate. There are people that what we call evade service.
Right.
And if people evade service, then they can come back and ask the court for an order of alternate service, meaning that you don't have to hand it directly to them.
Right,
But
you
you
can tack it
do-
on the door or something.
Yeah, you have to tack it, you have
Yeah.
to do it certified mail and first class mail, do things that would be reasonably calculated to
Right.
get a person notice of a
And he
lawsuit.
didn't do any of that. He didn't do any of that, and that's what I'm saying. She didn't listen to me, period. She didn't look into anything. Anything. He
Okay.
didn't do any of that.
So you believe she was expressing a bias because she
Yes,
didn't look
as a
into the
To the case, the details. and-
details of the
Of
service?
me, yes, of what I'm claiming, I showed up, what I'm saying. She didn't look at anything. So he didn't do any of that. He didn't do anything. He just was deceptive and did all these tactics that he's not supposed to do, and he got away with it. And she empowers that. It's an article that I submitted to her about these debt collectors buying debts less than $2,000 for pennies on the dollar, and they're targeting minority and predominantly black communities. There's a justice report.
Okay, well, what would you like her to have done with the article and the fact that
I would have liked
They
for her
might be,
to
quote,
look into
targeting
it
black
and listen, give me a chance and be just and fair, and not look at me and treat me like I'm a criminal because I experienced some financial hardship. I paid my bills. I had 11 credit cards that went bad. I paid them all. I'm down to 4. She didn't give me an opportunity to express and state my claims and show proof. She just recommended me, and she directly favored him and gave him the green light to do what he's doing. He never served me. He went to for a gun.
didn't we just say though that she ruled on the service and said that there was alternate service, so she didn't have to serve you?
And
They didn't have to serve you
Right.
personally.
but he didn't
That's
serve me at
something-
all. He didn't
Well,
serve
you
me,
don't think
period.
you got it served any other way? It wasn't tagged, it wasn't sent by mail, and nothing?
No.
There was no certificate, there was nothing?
No.
And wait a minute.
Here, she transitions from the judge was biased into my rights were violated. But again, without connecting these claims to actual judicial misconduct. She mentions improper service, abusive comments from opposing counsel, and discrimination, but none of these are linked to the judge's conduct. The chief judge asks repeatedly, "What did the judge do?" Instead of answering, the defendant keeps listing every grievance she has with the case itself. This is a critical moment, because it shows the difference between disliking how a case unfolds and proving a judge acted improperly.
I came up here. It's called register of action or something.
Yeah.
Yes, and 2 of the documents that the young lady documented saying, the windows was up, the lights was on. This was in May. And I was at work, both of those times. I worked 9 to 5. I was working in Redford. I work in outpatient. I'm a registered nurse. And I
So
work,
you believe that she should have held a hearing? As
yes,
to whether or not the service document was accurate?
yes.
Okay, well, if she didn't, how does that show bias? That means maybe she was wrong in what she did procedurally, and that's an appellate issue. How does it show bias? I have to get to actual biases. Almost, not totally. Very difficult, if not impossible
Yeah.
to show. You have to have a lot more than what you're saying, which is, her rulings on the particular case.
She favored him.
Okay.
And the article stated that these debt collectors are buying debts and targeting black communities and minorities versus middle class communities. They're targeting the black communities and minorities.
Okay, and you know what? Maybe that's true. But how does that mean I should recuse the judge because she didn't look at the article?
But isn't that her job?
To look at your article? No,
No, to look at the case.
Yeah, she has to look at the case for sure. But the question is, if you wanted her to look at an article about how the debt collectors are
She
targeted.
said I asked her, did she look at it? She did, yeah, I seen it and she did, and that's fine, she didn't elaborate. But
Okay.
she didn't look at the case and ask more, information from them. They never served me, Your Honor. They never served me.
I understand what you're saying, but that's an issue I can't deal with. I can't go back and change her ruling on the issue. All I can do is look and see if whatever she did was bias or prejudice.
It was. She was.
Well, that's what you say.
Right. And she made a comment to the Zoom. There was a Zoom hearing going on before my case.
Because
she referenced me to that Zoom hearing, whoever case that was. She made a reference to me, comparing me to that. I didn't elaborate because she was already.
One of the more dramatic claims is that opposing counsel made oppressive statements during mediation, a serious accusation. But even if true, that still does not prove the judge is biased. Mediation is private, and judges do not preside over or monitor those sessions. So the idea that a judge is responsible for something she never heard, never saw, and never was informed of is legally impossible. This is a turning point. The chief judge realizes the defendant doesn't understand what recusal is, and has tried to use this hearing as an all-purpose complaint session. The judge politely but firmly reminds her that mediation conduct has nothing to do with judicial bias.
I'm going to let him respond back to what you're saying now, and we'll go from there. Go ahead. What do you want to say?
This matter is simply about following the court.
Well, that's what I'm trying to explain to her.
Exactly.
Before you even start, I'm not trying to side with him. I was trying to tell you earlier that you have to follow what the rules say.
Yes.
And if she did or didn't follow those court rules properly, that's in a case for an appeal. And it wouldn't necessarily be that she's biased against you and for him. That's just a ruling. And unfortunately, in this job, we got to rule against somebody one way or the other.
I understand.
But if it's just a matter of court rules, I'm hearing, that's why I was telling you earlier, I'm hearing more of it. Sounds like she was just applying the rule on alternate service. Now, if you think you should have had a hearing on it, because she gets a chance to rely on what the process server said. But if you bring proof showing that what the process server said couldn't possibly be accurate, then I typically might hold a hearing on it and see if we can find out what did happen. But I don't know what you brought to her. And if she said, well, no, based upon what I've got here, it sounds like the service was okay.
This is one of the most important legal clarifications in the entire hearing. The judge explains, in the simplest possible terms, the difference between appealing a ruling and recusing a judge. The defendant wants her case overturned, restarted, or re-examined. But this is not the venue for any of that. Yet the defendant keeps merging the two concepts. Instead of presenting evidence of bias, she repeats she was unfair and she didn't listen to me. Those are emotional reactions, not legal standards. The chief judge's patience here is extraordinary.
Does that show bias?
I think she just ruled because the three document dates on the register of action, the 2 days I was at work.
Okay.
That was for alternate service, Judge.
Yeah, I'm looking at
So here's
she
what
got a
happened.
motion.
She was served by alternate service and she found an answer. And that's what Judge Argyle told her.
Okay,
She filed an answer.
let's look at that. So I'm looking at it right now. There's an order for alternate service for first-class mail tacking and certified mail return receipt. That's the things that we usually allow when someone is not able to serve personally. And that was signed on June 25th.
I responded July 17th.
Correct. She found an answer.
So
Which means she
how
was
did you, let me talk. Let's get to this. How would you know to file an answer if you weren't served?
This is with the alternative. I'm talking about the first order. I never received the first summons, the original summons. I never received.
That's okay.
Those are the 3
Let me
days.
tell you why it's okay.
Okay,
Because again, if they try to give it to you,
which they did not.
Well, I don't know if they did or not.
If you
They
look at the days, those, out of the 3 times that was documented, 2 of the days was work hours.
Okay, well, once they put that in and they say what they say, that they went to your home on a day, you say you're at work, we don't know specifically where you are. It's an ex parte motion. That means that we're only hearing from the one side. They tell us that they can't find you for whatever reason. Then we order the alternate service. The real issue is, did you get it by alternate service? And you must have, because you filed your answer. So there's really nothing wrong in that process.
It's failure. The law is failure.
Now, the defendant dives into broader social issues, debt collection practices, minority targeting, hardship, unfair systems, all important topics, but still unrelated to recusal. She's essentially arguing that because the debt collection industry is unfair, the judge who followed procedural rules must therefore be biased. But the chief judge cuts straight to the confusion. Alternate service is standard, legal, and widely used. Not receiving papers personally does not invalidate the case if alternate service was properly ordered. The defendant equates not getting what she wants with not being heard, which is a common but flawed assumption.
3 times. We don't have to go into a hearing on that because it's ex parte. That means that you don't have a say in that motion because you're not a party to the case yet. We're only talking to the people that are a party in the case. They're telling us we're having difficulty finding her.
Which is a lie.
Okay, that might have been. Maybe they were wrong.
Yeah, they were lying.
But I don't know. But that's what we get.
Right.
And so we don't go investigate to that degree. We take them at their word that they have not been able to serve you personally. And as long as they serve you alternatively, and we authorize that, that's good service, whether they didn't serve you the way you want it to be the first time or not, whether it was a mistake or they actually lied about it, as long as they got you served is what the courts are really, really concerned about, because you have to have an opportunity to come forward and be heard.
Right.
And you did have that opportunity.
On the second one, yes.
On the second one.
Yeah.
So she wasn't wrong in telling you, well, we're not looking at that because we got good service on you and you did file your response.
I did, and then I filed my response on the 17th, and then they came out again on the 23rd and tacked it to my garage door. No envelope or anything. The packet was really thick. When I pulled up at home, the packet was on the ground outside of my garage.
Yeah.
You know,
but that's still service.
And that brings us to the end of this courtroom saga. The chief judge's handling of the situation highlights exactly why the legal system separates appeals from recusals. A judge cannot and should not be removed simply because a party dislikes a ruling. What matters is evidence of bias, prejudice, or misconduct, and none of those were presented here. Instead, we saw a frustrated defendant mixing emotional distress with procedural misunderstandings. The chief judge showed remarkable patience, guiding her step by step to the law, clarifying the system, and explaining what this hearing actually allows.